Okay, so Ford explained this whole Parliamentary Privilege Certificate from the 1840 Parliamentary Papers Act and why we are eligible for it. And it's mainly to do with the newspaper, actually, and books and newspaper, but only because they're showing people something, right? Show-off, which is what a petition is, show-off, and the signatures, which are, you're collecting evidence of public concern, right? The signatures are evidence that you're collecting, and you're showing show-off, which is what a newspaper does, or a leaflet or pamphlet, right? So it's actually all about the newspaper or whether it's a book, but now you don't just show people things through books and newspapers, you show them it through, signs and banners or public representations. Anything which is defined as an advertisement under the Town and Country Planning Act, control of advertisements, or your own spoken word. Now, I've drawn this diagram here. So we've got this bottom line here. That's the court process, right? Which have always got the justices, right? The justices' circuits always lead to Parliament, right? Okay. And then here we've got the House of Lords and the House of Commons, okay, which is these two lines here. Now, I've done gaps in the lines because there's not always a Parliament, but you've always got courts, right? So here there's a gap in Parliament because there might not be a Parliament here, right? There might not be a Parliament there. So when there's no Parliament, there's no parliamentary privileges for MPs or Lords, okay? Or here, when it's prorogued or when it was dissolved or in between, when there isn't a Parliament, there aren't any parliamentary privileges. But what are you going to do? Well, you can petition the King and his council always, okay? And early on, you could do that through the justices, right? Because you could always, like the Bill of Exemption is an important example of that. Get a justice to stamp the Bill of Exemption to complain about him to the King, right? Or appeal to the King instead of having it heard by the justices, right? But the King sat in the House of Lords, and everything that gets put through the House of Commons, right, goes to the House of Lords, and everything from the justices eventually goes back to the King. So the King is literally the pinnacle here, because it all meets at the King there, right? Now, up until 1661, okay, you could petition Parliament, either of Houses of Parliament or the King anyway, right? But if you wanted to get you've got the right to, if you are the complainant and you're pursuing something, you usually got protection. We didn't have all this like policing law at the moment, which is all complicated legislation for police, right? For example, if you're going to apprehend a highwayman, right, as long as, he's done something wrong and you prove it, obviously you've got to do what you do to apprehend him, right? You could even get the reward of his horse or even title and so forth. Obviously, you use, whatever force and means to apprehend him if you prove that he was a highwayman, right? So whatever it means you use to apprehend him is not too much legislated on, right? And you've got all, there are a lot of laws for pardons and all sorts anyway, right? But if you are privileged, you got privileges because you got like servants of the House of Lords, and you can actually act for the Commons as well. So you've got this King's writ because your petition is the King's writ, whether or not it's on this justice's line here through the courts or whether it's on the House of Lords or Commons, it's still the King's writ, right? And if you need to enforce or back it up, you could get writs of privilege either from a justice, a judge, an MP, a member of the House of Commons, a member of the House of Lords, or the Speaker. That's always existed, right? Okay? At least when there's a Parliament, you can't get rid of privilege from Parliament when you've got a gap here, and there is no Parliament, right? But your document should suffice. Now, what are all these other lines here? So in 1661, right, following William Prynne and King Charles, right, what they do in 1661 is if you're petitioning Parliament, right? But they open up so it can be heard in the lower court, in the courts, right? So we're getting a parliamentary process that is allowed to be heard in the courts, because otherwise it wasn't. So we're bringing parliamentary matters, cases, down into the courts, right? Okay, and this is the Tumultuous Petitioning Act. Now, if it's a big petition, if it's only a tiny petition, you don't need to do that. But they're putting it into the courts, right? So a lot of your documents and that will be issued by the court, okay? Because you've got proper proceedings that you're going through, so you get everything's getting acknowledged, right? Now, in 1688, they give us in the Constitution our own explicit right to be protected for petitioning, okay? So we don't need these writs really anymore, these writs of privilege, because everyone knows that you're protected. And obviously if you've got a petition, then it's a proof that you're petitioning, okay? Or that you're pursuing that petition. So the petition itself is evidence. And, you know, what law backs it up? Well, it's made into the Constitution, so there's no doubt about it. So you can petition Parliament itself, but first you've got to get permission through the courts. Now, Parliament burns down here, right? And then they make this act in 1840, Parliamentary Papers Act, right? Because there'd never been any prosecutions really against actual publications up till then, but they got challenged. So they created in law a process by which you can get a certificate of privilege, okay? To if you got challenged on your constitutional rights, or anyone in Parliament as well, you could get a certificate from the Speaker, right? But the court probably would acknowledge your rights anyway. And remember, right, at this point, from this point onwards, right, you're not going to publish leaflets or a newspaper petition unless you get consent, because it's going to be to more than 20 people, right? So you can't have a newspaper or leaflet for a petition to Parliament without consent from the court. So you're going to have a court order, right, that you can do it, and that's a legally valid thing, a court order, right? What happens if the courts don't uphold it? Well, this is why you need to get Parliament to back you up, right? Now, similarly to bringing the House of Commons petitions, allowing them in the courts, in 1868, they do the same with election petitions for elections, because the MPs were not regarded as trustworthy enough to debate their own seats. So they allowed it so the courts may hear it. That's what they did in 61, because remember, before 1661, a petition to Parliament is for Parliament to decide, not the courts, right? The courts couldn't hear it. And this is the same as what's going on here in 1868. Now the courts can hear election petitions. The courts may do it, Parliament can as well, but no, it's a lot easier for people to go to court, and apparently the MPs weren't trusted to debate it, right? So we get it brought down into the courts. Now, the thing with election petitions is that if there's any members of Parliament being questioned, they've got privileges, right? And they might have to give evidence or documents. So those evidence and documents might be privileged. So they've got certain certificates and also to cover themselves. And we've got these certificates of indemnity as well. So we've got these two types of certificates will be relevant after 1868 in election petitions. Okay? Now, in why we've got this cross line here is because in 1986, okay, in 1986, they get rid of the Tumultuous Petitioning Act, which brought this down here, which brought these proceedings down onto this line here. So in 1986, we've got election petitions have gone down into the courts. Here, petitions to Parliament are removed from the courts, right? So they can't be heard in the courts anymore, right? So like here, you couldn't hear it in the courts, but then it gets brought down into the courts, and here it's going back up into Parliament and not in the courts anymore, only in Parliament. So courts no longer have anything to do with petitions to Parliament, so you won't get any documents or affirmations from them from the courts because they're not involved anymore, right? But you will get for election petition, because they've still got those in the courts with privileges certificates and indemnity, okay? So, now this is the thing. So we need the courts to recognise the law around petitioning, constitutional law since 1688, and the certificates, but they're not involved anymore in those type of proceedings, only for election petitions, okay? Now, the thing is, since 1661, okay, so from here until 1986, remember, we're here now, you don't need any permission at all from any courts to publish anything in the newspaper or in leaflets or pamphlets. You can print your own petitions or print a newspaper or whatever you want without permission from the courts, right? The lower courts or anyone, right? But in between here and here, you had to have permissions. Now, what happens if you put it in the newspaper, right, to show off people the evidence, right? Because it's going to go to Parliament, it's going to be before Parliament, right? You might get prosecuted. Someone might not believe that you've got consent from a court, or another court might not believe you. So they might prosecute you for putting it in the newspaper, right? Or printing leaflets, because they might not believe you've got consent from the court. So that's another reason why your certificate of privilege from the Speaker of Parliament, right, might be needed. And what even is the newspaper? Well, the newspaper's the petition. And it's an advertisement, word, letter, sign, notice, model, representation. It doesn't have to be in paper form. It can be illuminated on a device. It can be verbally, however you want, under the definitions of advertisement, because it's to showeth. It's to showeth people you're displaying it, right? And you're collecting signatures. A lot of the petitions that they had in the newspapers actually is like what I've been doing, where you can sign the back of it. And lots of people were doing that. I mean, I've got some from the Royal Automobile Association, but they might have ended up being prosecuted. Now, it doesn't matter whether it's in a newspaper or whether you're walking around with them in the backpack. You might have the leaflets in a backpack, right? You might get prosecuted for having them. Did you get consent to do that? And the thing is, we've got now, you might have had a court order to prove it, but now there is no court involved in it unless you happen to be doing something for a petition and you get prosecuted. But this is why we need the certificates of indemnity and privileges. Just like in an election petition, people are appearing in court and giving evidence, but they might be found guilty, but they don't get prosecuted. But the thing is, in the election petition rules, right, even if you're privileged, you've got to answer questions still. If you're an MP or a member of the House of Lords, you've still got to answer questions, because that's what the rules are. But because your privileges or indemnity, you might not actually suffer. But this is why they send a report to the Speaker of Parliament, and then you've got the Privileges Committee and so forth will decide what to do with them, right? And so forth. But there are different rules, and it depends whether a person gets an indemnity certificate or not. Not all people get them, right? It depends if you've got covered with agency and you answer questions honestly. So it's actually very important. The Parliament certificate is for the parliamentary privileges part of it, as much as the indemnity certificate. And you know, it's a parliamentary document. It's to be evidence that you're gathering before a committee. When you show off this in a newspaper, right, and you're getting people to sign it and send it in to you, then you're going to give it to Parliament, right? So that's what the certificate's for. And you might be walking on the street in a backpack. You might have a banner or a sign up saying it on it. And this is what we're contesting now with Sir Lindsay Hoyle and the Speaker's office with these Stop ULEZ petitions when we've proved agency, because we've proved that there are Stop ULEZ petitions, and there are even some MPs who've been doing petitions for it and encouraging them to do it, and even hanging around with them, even members of the London Assembly, even councillors. So we know the agency's there, so therefore they're covered with it, and there are existing petitions. So it definitely is. It's actually the newspaper and books, newspapers and leaflets, because that's all they had really in the 1800s. But now it's digital as well, but in person, because you got these in your hands, you're holding them, you're making use of them in your hands in the street. Okay, so that's basically the timeline of it. So it's what they're doing with the election petition, bringing it into the courts, is what they did with brought the House of Commons petitions into the courts first. But then they're taking it back out again. This one, they're taking it back out, whereas this election petition is still in the courts down here. But you can have it heard in Parliament still, which is something else we're debating with the MPs. And there's also things about local petitions as well, which, planning applications aren't meant to be considered as local council matters anyway. So, this is basically the basics of it.